Hi, good morning, everybody. Welcome to our Let's Talk About Debt Solutions Scotland, which is part of our Talk Money Week webinar series. And that's going to be delivered today by Thomas, who is our money advice supervisor based up in Scotland. Before we go on to the presentation, I just wanted to talk a little bit about the charity for those of you who might not be aware of us and what we do. Our vision is to be a supportive community in which everyone has the chance to live their life to the full. And this is who we are and what we do. We offer a range of services and support online and offline, both from ourselves and from other specialist organisations that we're partnered with. It's important to say that each service is dependent on your situation and eligibility, and we would normally check eligibility using your national insurance number or wage slip. If you're not sure if you're eligible or whether it's something that the charity can help with, the best thing to do is to contact us and to ask. We know that life isn't black and white, and neither is our offer of help. So we really do look at everybody on a case-by-case basis. In terms of who we help all serving, former or retired civil servants and their dependents. So they can seek the charity's help at any time. We're not a membership organisation, so you don't need to have donated in the past in order to be eligible for help. It's great if you do, but there are many ways you can support us, but it's not a requirement to have donated in order to apply for help. So just before we move on to the presentation, if you do have any questions, then please pop them in the Q&A and we'll try to answer them all at the end of the session. So I'll now hand over to Thomas, who's going to talk about debt solutions in Scotland. Thanks, Thomas.
Thanks, Jane. Thanks everyone for coming along to our presentation on Scottish debt solutions. Just as a quick intro, my name's Thomas Linus. I'm a money advice supervisor with the Charity for Civil Servants. My main role is to deal with the money advice cases that come in from Scotland, but I also work with English cases and I'm qualified to do so. I've been with the charity for almost 8 years, and prior to that I've worked in a local authority money advice service. I've also worked with an insolvency practitioner where I was a designated money advisor. So in total I have around 13 years experience. In addition to my day job, I also work as I also am a director of Money Advice Scotland, which is an umbrella charity that aims to support money advisors in training, and as well as influence policy on matters affecting money issues within Scotland. So today we are focusing on debt solutions in Scotland. We're going to cover subjects such as financial statements, how to apply for a hold from enforcement action, non-statutory debt solutions, and statutory debt solutions. With more and more household budgets being stretched, it can be important to know the options that we have available to deal with our finances and bring them under control. I should start off by saying that Scotland does have its own set of rules for dealing with debt compared to other areas of the UK. If you are considering taking on a debt solution following today's session, you should discuss your position with an impartial, independent money advice agency, such as our charity or similar organisations, Citizens Advice, or a local authority money advice service. Please be aware that there are private companies who can also offer to help you, and they're very prominent online and easy to access. However, in some instances, these options offered are not completely impartial, and you could be charged fees for services that are otherwise free. Financial statements are the starting point for most money advice sessions. It creates an overview of our finances and helps us to understand the situation we're in. It also helps us to prioritise essential spending such as mortgage, rent, council tax, utilities, etc., as well as budget for less important factors like leisure activities, socialising. A financial statement itself can be a debt option as it is a basis for budgeting advice. For some people, a debt solution may not be appropriate as they wish to prioritise maintaining a credit rating, or they may have restrictions on entering debt solutions as part of their contract of employment. And in these instances, budgeting will be the main solution to consider. For all other debt options, the financial statement would determine how much our clients can afford to pay towards debt. In Scotland, money advisors prepare financial statements under the Common Financial Tool. This tool is generally accepted by creditors when considering debt repayment offers, although there are still some creditors that wrongly insist that we must use the financial statement used in England. The Common Financial Tool helps the advisor build a statement using trigger figures to control spending in subcategories such as phone, travel costs, housekeeping, and other expenditure. These trigger figures are not publicly available, and the advisor uses these as a guide when reviewing if a budget is suitable for creditor acceptance or not. There may be times when figures are breached, and as long as there is a rationale for doing so, they may be justifiable to creditors or statutory authorities. For example, if you live in a rural area and have high travel costs, generally overspending here would be justifiable and allowable. At the same time, there may be instances where breaching these figures may not be acceptable, and an advisor may need to discuss budgeting options with you to control spending to make your statement acceptable. Before we get to debt solutions, you may need to consider a moratorium. A moratorium is an official hold from creditor enforcement. Most debt solutions can last years, and they are not options to be entered into lightly. It is recommended you should take at least a week after taking advice to consider the suitability, pros and cons of any option you wish to progress. Moratoriums can be useful if you've received a charge for payment document. This is your official notice that a creditor intends to take action against you, and the moratorium will allow you time to speak to a money advisor, consider what options are available, and put those options into practice. The moratorium will hold sheriff officer enforcement, such as arrestment of bank accounts, earnings arrestments, or attachments, including exceptional attachment. Applications are made fairly easily and they can be registered in days. It can be done by yourself, but generally you should ask a money advisor to submit this on your behalf. Moratorium can last up to 6 months. However, it's important to remember it is not a payment break. You will still need to deal with your creditors during this period, and they can continue to contact you. They just can't take enforcement action. It does not stop interest and charges accruing, nor does it stop court actions. You should also make sure that you continue at least to focus on your priority spending, rent, council tax, etc. while you're in the moratorium. It will also not stop any enforcement action that has been taken against you before it was registered. There are restrictions on the number of times you can enter a moratorium, and you should not enter this unless you're under real threat of enforcement in the short term. You should save using it until it is actually needed. While under a moratorium, you should be working with your money advisor to enter a debt solution or self-negotiate with creditors. You should note that your details will be held on a moratorium register which is available to the public. Moratoriums should not be confused with breathing space or the debt respite scheme, which is a similar in theory solution, but very different option available in England. It is not available in Scotland, and I feel that I should mention this because sometimes, again, wrongly, creditors based in England will encourage Scottish clients to enter breathing space when it's not appropriate to do so. Informal debt solutions are options that are agreed between you and your creditors out with the protections of statutory debt options. However, if your creditors are FCA regulated, they still have a duty to deal with you fairly and reasonably. These options are mainly self-administered, but in some instances, you may be able to get an organisation to help you with offers and the distribution of payments. It is important to remember that these options are unlikely to work on priority creditors. Again, your mortgage, rent, council tax, etc. And you would need to negotiate those separately. Those negotiated offers would then be on your financial statement when you do make your informal offers to non-priority creditors. These options are only likely to be acceptable under certain conditions, and even if your creditors are in full agreement, your credit rating is likely to be negatively impacted. First option, creditor forbearance. So if your financial situation is poor and unlikely to change, you can ask your creditor to write off all or some of your debt or freeze interest and charges to make your situation more manageable. It can be rare for these to be acceptable, but in some situations when a financial position is unlikely to improve, if you're a pensioner or you have a long-term health condition which is impacting your income, they can work. Full and final settlement. If you have a lump sum available or you have a family member who is willing to help you out financially, you could offer a percentage full and final settlement to all non-priority creditors. The success of this is likely to be dependent on your ability to repay. So if you have the means to repay your debt over a medium to long term, a lower offer will not be acceptable, while a higher percentage may be. On the flip side, when you have little to no disposable income, and it's unlikely to change, you will have a better chance of a lower offer being accepted. Token payments. If your financial statement shows that you have little to no disposable income, you could offer token payments. Usually these are around £1 per month until your situation improves, and then you can look to increase payments in the longer term. This can be beneficial in allowing you to make higher arrears payments to priority creditors. Debt management plan. This is an informal agreement between you and your creditors to repay your disposable income at a pro rata rate based on your financial statement. If accepted, normally interest and charges can be frozen, but you should know that a debt management plan works very similar to the debt arrangement scheme, which we're about to go on to under statutory debt solutions. The statutory version offers far more benefits and protections and should be considered before this informal version. Now we're going to go on to the statutory debt solutions available in Scotland. We're going to cover the debt arrangement scheme, as mentioned on the previous slide, and we're also going to cover the main insolvency actions such as protected trust deeds and bankruptcy. Statutory debt solutions in Scotland are administered or supervised by the Accountant in Bankruptcy, which is a Scottish Government department. If you enter any of these solutions, your details will be held on a public register unless you have valid grounds to be omitted. As discussed previously, the debt arrangement scheme is a very similar solution to an informal debt management plan. With the assistance of an approved advisor, using your financial statement, an offer is made to creditors to accept a pro rata payment towards your debts. The main difference compared to the debt management plan is that if your creditors reject your offer, you will be subject to a fair and reasonable test administered by the Accountant in Bankruptcy, who will decide if it is acceptable. There is no set rule for approval, but generally if your plan can be completed in a reasonable amount of time and there are no major breaches in your trigger figures, it can be acceptable. You may not need to commit all your disposable income into the plan if that is the case. Trigger figures are not strictly enforced and the plan can be a bit more flexible. If accepted, you repay 100% of what you owe on that date. Interest and charges may not be added, and if they are, they should be removed once the plan completes. Your creditors will receive around 80% of the money you owe them, and the remainder is used for distribution and supervision costs. Unlike informal plans, you can include priority debts like council tax and utilities. However, rent and mortgage arrears are usually dealt out with the plan, as you could still have your property repossessed or be evicted if arrears payments aren't made to the satisfaction of your mortgage provider or landlord. The debt arrangement scheme can be flexible and it can be amended if your circumstances change, good or bad, so long as it can be completed in a reasonable time frame. There can also be provision for emergency payment breaks if unavoidable events happen. So it's important to note that these unavoidable events are not for needing extra money for holidays or Christmas. They're more for if your washing machine breaks down or you need an emergency repair to your boiler, things like that. And finally, just on the debt arrangement scheme, the debt arrangement scheme will have a lasting impact on your credit file, even though you are paying back 100% of what you owe. Next option is protected trust deeds. In some instances, a protected trust deed can be a useful tool for dealing with debts. However, it requires a specific set of circumstances to be met to be beneficial over other options like the debt arrangement scheme or bankruptcy. Through an insolvency practitioner, you will make an offer to pay a contribution over 4 years, along with an agreement to deal with any assets you have. Assets would include things like your home equity, cars, valuables, savings, things like that. In some instances, unless agreed otherwise, you or your trustee may need to sell assets to comply with the terms of your trust deed, and you may need to surrender savings. The value of money gathered from contributions and assets, minus trustees' fees and expenses, usually needs to be sufficient to make a minimum offer of 10 pence in the pound towards your debts. The remainder would be written off once your plan completes. Your creditors have voting rights on whether to agree on the plan, depending on their value of debt. But if a sufficient amount of creditors do accept, your trust deed will become protected. However, if your trust deed is rejected, this can be grounds for you to be made bankrupt. Once protected, you will be required to maintain the contribution and deal with assets, and failure to do so may result in your plan failing. This could mean some or all of your payments that have already been made are eaten up by fees, and no money could go towards your creditors, who in turn can add back interest and charges. Additionally, you are duty bound to increase contributions if your situation improves, and if you come into money through an inheritance, lottery win, or something similar to a PPI claim, your trustee will seek to gather those funds to repay creditors with. Protected trust deeds are mainly managed by private firms, and due to the fees involved, there can be pressure to get you to sign up to these when it might not be entirely suitable for you. If you are considering this option, you must ensure you read all paperwork provided thoroughly and that any financial statement used is accurate and sustainable for the duration of the trust deed. You should consider how a similar contribution would work in a debt arrangement scheme, or if you could enter the bankruptcy and pay less. If possible, you should always ensure that you have spoken to an independent money advisor about the suitability of a trust deed. Bankruptcy, or sequestration as it is more commonly known in Scotland, is a formal insolvency and usually lasts around 4 years. You can apply for your own bankruptcy, or your creditors could also apply to make you bankrupt if you owe them over £5,000. Under a bankruptcy, your finances fall under the control of a trustee. The trustee will assess if you should pay a contribution, but unlike trustees, you're not required to meet a certain target of contribution in order to satisfy creditors. And if you are assessed as not able to pay a contribution, you may not have to pay anything at all. Similar to trust deeds, your assets will be taken into account, but your trustee in bankruptcy will have more control to sell items if you cannot agree on a strategy. If you're applying for your own bankruptcy, agreements on contributions and assets are usually made before you're declared bankrupt, and you can withdraw from the process if you're not comfortable with that agreement prior to the final submission of the application. However, once a bankruptcy is awarded, it is extremely difficult to overturn, and your trustee will retain an interest in contributions and assets until they are discharged. And it is therefore recommended that you're completely upfront and truthful on your bankruptcy application. There are certain conditions to meet to enter bankruptcy, such as minimum debt levels, residence test, and you may have to pay a fee of around £150. In some instances, that can be waived. Bankruptcy is usually considered a last resort to deal with finances and can have a lasting impact on your credit file. It can also have an impact on some contracts of employment and tenancy agreements, so your job and home could be at risk. Additionally, some vehicle hire purchase contracts can include a bankruptcy clause, which means that you could lose your car also. Under bankruptcy, you're placed under certain restrictions until you're discharged, usually after a year. If you do not properly comply with a bankruptcy or do not declare assets from the process, you can have your discharge period extended under a bankruptcy restrictions order. Restrictions include acting as a director of a limited company or becoming a member of Parliament, as well as some limits on the amount of credit that you can obtain. Discharge does not stop your contributions, and you will still be required to pay these over a 4-year period if applicable. Future assets can impact a bankruptcy, so you shouldn't enter if you are expecting any money in the future, say around 4 years from the time you enter the bankruptcy. At the end of the process, your debts are written off with a few exceptions. Some of the exceptions include things like student loans, overpayment of benefits which are acquired through fraud, or criminal fines. While bankruptcy can include rent arrears, your landlord could still take steps to evict you. Normally, mortgage arrears would not be included in a bankruptcy, although they can be if it's for a former property.
Thanks, Thomas.
Oh, sorry, I've just skipped over the minimum asset process, James.
Oh.
Sorry about that.
Sorry.
So I'll just quickly cover off that. It's just a quick slide. The minimal asset process, or MAP for short, is a shortened version of bankruptcy. The outcome in terms of debt write-off is the same as normal sequestration or bankruptcy. To enter a MAP, you need to have little or no assets, and following preparation of your financial statement, you should have no disposable income. There is an upper debt level of £25,000, so if you're above that, you can't enter a MAP. The term of a MAP is roughly around 6 months to discharge, and usually there's no fee to pay. It's particularly useful for people on low incomes with no money. Future assets can impact a MAP, so you shouldn't enter it if you are going to be expecting money in the future. So yeah, that's just a brief addition to the normal sequestration bankruptcy procedure. Sorry. So yeah, sorry, that's me now. So thanks for listening, and I am happy to take on any questions.
Thank you, Thomas. Yeah, I've got a few questions that have come in. One is, can you have more than one moratorium?
Not within the same year. So you can reapply after the year. So yeah, the answer is yes, but again, ideally, you want to save that moratorium for when you need it, and if you are in that moratorium, because it's such a long period, you should be looking to enter a debt solution within that time frame.
Okay, thank you. Another question is, can I register my own moratorium, or do I need a money advisor to do that?
The answer is yes, you can. Up until about 3 months ago, it was fairly easy. You just had to go onto the site. The forms were there, an email address was there. All you had to do was print off the moratorium, sign it, send it to the email address, and it would get registered, providing there was no missing information. But the information is basic. There's no financial information. It's just name and address and a declaration. They've changed that, and now it's done through their Registers of Insolvency site, which is accessible to the public, so you can do it, but it's not as straightforward as it was, say, 6 months ago. So I would recommend that if you were considering a moratorium, that you get a money advisor to do that for you.
Okay, thank you. Another question is, would you always recommend a DAS over an informal debt management plan?
Personally, I've never seen anything to swayed me that there are benefits to an informal plan. It has been informally mentioned that some people cannot enter any statutory debt solution as part of their contract of employment. If that is true, then that may be an instance where you want to avoid the debt arrangement scheme and go into the debt management plan. But in practical terms, I've never seen any evidence that that could be the case, and that someone would be penalised for entering a debt solution. But if someone isn't comfortable doing that debt solution, even if there may not be any grounds, if they are more comfortable doing a debt management plan, then that's their choice. And we would always be supportive of people doing things that they're most comfortable with.
Okay, and just one last question is, what happens if a trust deed fails?
If a trust deed fails, it is effectively null and void. Your debts are handed back to you. What happens in Scotland is that there are some requirements for trustees to distribute some funds to creditors throughout the duration of the trust deed, but those figures are usually quite small. So if it does fail, you're not granted your discharge, so your debts are handed back. Your creditors will be able to pursue you. They'll be able to add interest and charges, and you'll find that the money that you did pay into the trust deed will be minimal. There will be minimal amounts of that money goes towards the creditor balances.
Okay. Okay, thanks, Thomas. That's the end of the questions. Just before we finish up, I just wanted to tell you a little bit about our money advice and guidance service. So if you are struggling with debts, the charity does have a money advice and guidance service. We offer free, impartial, independent money advice with the idea of bringing unmanageable debt under control. We've got a team of experienced qualified advisors, all members of the Institute of Money Advisors or Money Advice Scotland. We're regulated by the Financial Conduct Authority, and we've got advisors based in all regions. So that includes Northern Ireland and Scotland, where legislation just differs slightly. So we are able to provide country-specific debt advice. So whether it's just that you need a little bit of help setting up a budget, or you're struggling with multiple debts, we can help. We can advise on dealing with priority debts, including advice on court action, as well as budgeting and managing money, and advising on setting up informal reduced payment plans. We also advise on legal options for dealing with debt. So that can be things, as Thomas has talked about, trustees, debt arrangement schemes in England and Wales, debt relief orders, IVAs, bankruptcy. You'll find a lot more information on our website on the debt options available, and that is split up into England, Wales, Scotland, Northern Ireland. So there's country-specific information there. We know that money worries can be a major source of stress and anxiety, and that it can be very difficult to talk about money, but we just want to let you know that help is available. So if you are struggling, please do get in touch. Just to finish off, we are running a series of webinars for Talk Money Week. There's a list on screen. We are currently, as you can see, up to Debt Solutions Scotland. We've got a GamCare gambling harm webinar this afternoon. If you're interested in any of the webinars, you can register via the website. So if you go onto the website and look at the help and advice section, there's a webinars section that you can find details of them to register, or you can use the QR code on screen. There'll also be recordings of these webinars, all except the GamCare gambling harm webinar will be available on the website going forward. So I would just like to say thank you very much for joining us today. You can find more information about the charity in terms of the help we offer, and also access to various resources on our website at cfcs.org.uk, or by using the QR code on screen. Thank you very much for listening, and I hope that you will join us for other Talk Money webinars. Thank you.
Thank you.